All right, we are on the record. 462464, the Gibb matter. Mr. Willick, your appearance, please.
Good morning, Your Honor. Marshall Willick, 2515, for Plaintiff Farrah Kaufman, formerly known as Farrah Gibb.
Thank you. Mr. Gabato?
Good morning, Your Honor. Alex Gibato, 10592, on behalf of Kristen Gibb. I don't think he got a link, Your Honor.
You don't think what? I'm sorry?
I don't think he received a link for the hearing, but I'm fine waiving his appearance.
Okay. All right. We're on today, essentially a continuation from the hearing on June 16th, and then we had a stip to continue the return date. I did receive Mr. Willick's supplemental submission and reviewed that. I didn't receive a response, Mr. Gabato, to Mr. Willick's submission. I did get the affidavit you talked about on the 16th. It was filed at almost 9 o'clock last night. Luckily, I had some time this morning before court. I was able to review that. So, based upon those, is there anything else I need?
I don't think there's anything else, Your Honor, unless you want a brief from me. I thought that the affidavit sufficed. I think that it was important for Mr. Willick to lay out some of the claims that he was making that weren't in his opinions before, and that's been done.
Okay. Mr. Willick, anything else?
The only additional points that the court has reviewed the written filings is the stuff that was brought up for the very first time yesterday night in this supplemental affidavit, which I'd like to very briefly address. Basically, after claiming to be an honest and upstanding fellow for a couple of pages, for the very first time in this litigation, on page 2, lines 9 through 15, Mr. Gibb makes the claim that there are no pilot retention bonuses. Obviously, I don't know as a matter of fact whether that's a true assertion or not. You would have thought, since it's been in litigation for the last 6 months, that if there was no such asset, someone would have thought to mention that sometime during the last 6 months. I am reminded of Ronald Reagan's famous adage about, well, trust but verify. This goes to my request during the last hearing to reopen discovery sufficiently to allow us to send a subpoena to DFAS to ascertain the truth of various matters. The same thing applies to the Thrift Savings Plan on line 22 of the same page, where he claims that while it exists now, it didn't exist during the marriage. That may be true, it may not be true. If our form OID simply calls for the Thrift Savings Board to divide that which was accumulated during the marriage. So if our form order goes in, and in fact he's telling the truth, what will come back is 0, because 1/2 of 0 is 0. We, again, simply do not know the truth of that representation. On page 3 of this affidavit, he makes a claim that some unnamed clerk told him that this court doesn't have jurisdiction to allocate the SBP to the former spouse. I would respectfully suggest that Congress has held otherwise. We have given you, I would like to believe, quite adequate chapter and verse with citations to federal law, adequate for the court to deal with the question of jurisdiction of the court to allocate the SBP. Now that we know, or at least we have been informed, that Mr. Gibb is still active duty and will be for another 2.5 months, we have resolved the question that Judge Duckworth was uncertain about. He questioned the court's jurisdiction to allocate the SBP. We have provided on pages 5 and 6 of our supplement the information indicating that the court has complete jurisdiction because there is no prior court order indicating that the former spouse is to be the SBP beneficiary. So the court has the jurisdiction to allocate the SBP to protect the spousal interest. We have given you the analysis indicating that when choosing between spouses for the allocation of that benefit, the spouse with the largest timeshare interest is the appropriate SBP beneficiary. We have given you the math showing that that person is Farrah Kaufman, and that she should be the SBP beneficiary. If the court is looking for a equitable way of addressing that question, you needn't look not much further than that same page of the supplement, where Mr. Gibb says, I have no motivation to actually get insurance on me. I am not going to cooperate. It is too invasive. I won't submit to a test or procedure or revealing medical records or anything else the insurance company wants. He would have that motivation to protect his current spouse, apparently. So if the court is looking for a reason why the former spouse should have something provided by the government and the current spouse should have something based in insurance, it is the motivation of Mr. Gibb to actually cooperate with getting it. He has refused to cooperate with obtaining private insurance in replacement to the SBP for over a year, actually 3. I see nothing in his current filings, nothing in his court appearance, nothing from opposing counsel indicating any indication of an inclination to cooperate in the future. The SBP window will close in 90 days. The court has only until the day of retirement to issue an order naming the former spouse as the SBP beneficiary in order for that to be an enforceable court order. And we think that that is the appropriate result. As far as his claim that insurance can be obtained without having to undergo any testing or procedure or submission of medical records, if that's true, then he should have done it. For the 3 years that it was ordered to be done, that he has shucked and jived and avoided. The same fellow who claims to be so upstanding and honest is the fellow who told me in writing less than 6 months ago that he wasn't going to be eligible to retire for another 15 years. And then told you in open court that he's retiring in 90 days. So no, we don't actually trust any representation that he makes on any contested issue of fact. And we don't believe that Farrah's rights should be subjugated to a requirement of his future cooperation, since he has demonstrated for 3 years that he will not cooperate and he will not do the things that are necessary to provide the substitute benefit. So we think that the court should exercise its jurisdiction to do what should have been done in the first place, which can be done right now, and name her as the SBP beneficiary so that she doesn't lose the benefit of the pension benefits, and the distribution of benefits and burdens is made equal between the two parties. It's an aside, but the Academy chapter met on this yesterday, and we'll be going forward with proposals to make sure that that is the default in all cases sometime in the future. But in the moment, it has to be done case by case by case. The only other things from this affidavit that are worth mentioning that are not addressed in the prior filings, again on our page 3, he makes the unsubstantiated claim that I've always carried life insurance naming Asher and Zaria and will continue to do so. He supplies no evidence whatsoever that that is true. We have been requesting that for a year, at least 6 months. There is no evidence that any such insurance is in place. If it is in place, there is no evidence of any kind how much. And the MSA calls for it to be in a minimum amount of $400,000. You would think after 6 months of requesting documentation, if he was telling the truth, and again, I don't know as a matter of fact whether he is or is not, it would have been a simple matter to attach the insurance confirmation sheet to the back of his affidavit saying, here is the insurance that I have on the kids and I will keep it in place. He didn't even do that. We are simply supposed to take his word, even though he's already admitted making multiple false representations just in this round of litigation. His college response is totally non-responsive. He says that he's named the children as recipients of the GI Bill. I don't even know if that's legally possible at this stage in his career. It may be, it may not be. But again, the only person with any evidence is him. So he hasn't supplied any evidence that anything he has said is true. We think the court should do what we asked the court to do previously. Since he won't provide the evidence, a DD 214 showing the actual retirement credits, which would allow us to derive a spousal overlap and therefore give Farrah Kaufman the percentage of the retirement that she should have, the court should simply order that we supply and you sign and we enter an OID giving her 50% of the total retirement benefits until and unless he provides information which shows that it should be some lesser amount. He has full control of the information. He could do so in literally 2 minutes at any time. Could have done so during the 3 weeks that my opponent asked for as an extension to respond to our supplement and never did. He supplied nothing. He supplied no evidence. He supplied no information. He supplied nothing useful to move this thing around forward. It is simply more of the same shucking and jiving and delaying and avoiding that he's been doing since 2016. So we asked the court to do what it is we should do. We asked the court for an order right now, well, under submission, however you want to do it, to issue a direction to us to submit an OID giving Farrah Kaufman 50% of the military retired pay, making her the SBP beneficiary, supplying 1/2 of the marital contributions to the TSP, and ordering him on a short leash, like a week, to supply evidence of the insurance, evidence of availability of the college funds, and anything, and there's a few ancillary small issues. I'm sure the court has them listed. And then to reserve jurisdiction over the aircrew incentive bonus long enough for us to subpoena the information, since he won't voluntarily supply it and simply says that the benefit doesn't exist. It's frustrating that the person with ready access to the information, which would have allowed this court to address matters on its merits right now today, has chosen instead to evade, avoid, and refuse to supply that information. If any of these representations are true, all that documentation could have been supplied months ago, and we could have saved a huge amount of time and effort. That last point simply brings us to the question of fees. Obviously, that's discretionary. We ask the court on its review of everything to take a look at who's been telling the truth, who has been shucking, jiving, and lying, who has caused an increase in the total cost of these proceedings, and to allocate fees accordingly. I'll answer any other questions if, upon review of any of these materials, I realize this supplement had a lot of detailed information about retirement and survivorship and other matters. If the court has any questions on any of that, I'd be very happy to answer them, because sometimes people get lost in the details. Thank you.
Thank you. Mr. Gabato, anything else?
Hey, Your Honor. So first, as to the supplement, what I was expecting was that, like Mr. Willick had said at the last hearing, a couple of links or citations to cases. Instead, we got a book. I don't have the time at this point. I'm in the middle of a move to do a reply, a whole nother set of briefings, nor does my client have the money to pay me to do that. So we submitted the affidavit, which is actual evidence. That's his testimony, Your Honor. As far as the remainder of what was stated, the bottom line is that my client didn't start their savings plan until after the divorce. And if this court wants further proof of that, I'm sure we can provide it. As far as the survivor benefits, it's the case of Henson and B. Henson is on point. Your Honor, and it specifically states that the holding there was that because the divorce decree did not explicitly provide the litigant there with a survivor benefit interest, she's not entitled to one later, subsequent to that. So I think that addresses the issue of the survivor benefit plan. It's addressed by the Henson case, not least of which the fact that they're asking for this 6 years or 8 years after the fact, or however many years it's been since the decree of divorce. It's too much. My client has since gotten married. He's moved on with his life. He has a child. He shouldn't be forced into this. It was entered into 8 years ago before any of that. That's why latches applies in this case. That's why latches matters. To allow people to move on with their lives without being haunted by their past 8 years down the line. As far as I don't know what else. The pilot bonus, he didn't get any. That's just a fact. That's his statement. I don't know why Mr. Willick would think that he would put that in writing and swear to it, only to lie when it's easily discovered whether that's a lie or not. He doesn't have one, bottom line. He does provide life insurance for his kids, and as for life insurance for himself, he doesn't need to submit to an invasive procedure when she could get life insurance for him without that. Why does he have to go through that? It doesn't state in the order that he needs to submit to that, and he doesn't want to. That should be the end of the inquiry. If she wants life insurance, get it. You could get it without it. That's where we're at with that. I don't know what else there is as far as the retirement, Your Honor. Again, stated in the briefing, it is too late to demand that this court compel my client to do anything. With that, unless the court has any more questions, I'll submit on the briefs, Your Honor.
All right, thank you. All right, the question that the court is faced with at this stage is, when is an order final, and should the court expect people to follow orders once they are final? This matter has been litigated several times. Judge Duckworth dealt with this issue on numerous occasions, and notwithstanding the continued reference to the need to comply with court orders, for some reason the defendant has not complied with court orders. Now, plaintiff is not completely without responsibility in this either. There was a suggestion by Judge Duckworth back in 2015 with regard to the SBP to give her the option of obtaining a life insurance policy, and it doesn't look like that occurred or it was even pursued until the last 6 or 8 months to this stage. It's difficult, and the reason that Mr. Gabato is arguing what he's arguing is because when this much time has passed, it is difficult for the court to try and recreate what should have happened. That being said, a party is not entitled to benefit from their refusal to cooperate with a court order just because time has passed through that time frame. So the court's considered the totality of what has been presented to the court as well as the arguments and hopefully orders that will be final to this stage. Information must be provided with regard to the OID so that accurate quadros can be prepared. This is one of those issues that this case goes back so far that Mr. Snyder was the one that was tasked with preparing the quadro, and the defendant was tasked with paying and with cooperating years and years ago, which still has not happened, which is another reason why you don't get to benefit from your refusal to cooperate. That information needs to be exchanged. I don't believe that I have the jurisdiction to sanction a party with additional separate property rewards outside of the community property distribution which occurred back in 2012, so I don't believe I have the ability to grant what Mr. Willick's requesting and simply give 50% because the court's aware that 50% is more than the community property share. However, we do need cooperation of the defendant in order to make that happen. So I'm opening discovery for obtaining that information. The court is anticipating that the defendant will cooperate at this stage. If he does not, then dollar for dollar efforts that Mr. Willick has to put in place to obtain that information will be awarded by this court as a sanction for failure to comply and to cooperate. You're not going to get a benefit for not cooperating. In fact, you're going to get a detriment. This needs to be done and should have been done years ago. Judge Duckworth tried and was unsuccessful in making that happen. The same requirement goes for the points earned. so that those benefits can be calculated. As far as the reimbursing the plaintiff $100 for enrolling in Our Family Wizard, that's not the appropriate resolution. The appropriate resolution is that if the defendant does not enroll in Our Family Wizard, which was required in 2 weeks 5 years ago. So I don't understand why that's a difficult thing to accomplish. All of my litigants are able to pull that off in a matter of minutes rather than years. So the requirement is still in place. That's a court order. It should be complied with. The life insurance policy from the marital settlement agreement on page 9 is a separate question, and the court is confused with regard to where we are on this. I don't understand why, at this stage of the litigation, I'm just now learning that there's already life insurance in place. Because all that was requested many months ago was, show me proof. And all I have is a supplemental affidavit filed at almost 9 o'clock last night, now saying, oh, it's there, it's already done. The reality is that I've got some concerns with regard to statute of limitations on that issue, on the $400,000 life insurance from the marital settlement agreement. I believe that I don't have jurisdiction at this stage to enforce that, but if it's already in place, then that information needs to be exchanged so that we can deal with that issue. As far as the bonuses are concerned, the court must enforce the order. The order itself indicates that defendant is entitled to the bonus. I don't know what has changed with that other than an affidavit I received last night at 9 o'clock. It's also indicated, it's anticipated that it'll be started in 2016. The language of the decree refers to this bonus, and the court had some difficulty and mentioned at that time because it didn't say bonuses, it said this bonus. But the way that the paragraph is structured, the court presumes that it's more than a one bonus that was anticipated. So pursuant to that section of the prior order of the court, the plaintiff is entitled to her percentage of those bonuses. Now I'm learning, I don't know why, I'm just now learning, that those bonuses were never received. Well, the court has a credibility question with regard to other information that's been received, so this court, like Mr. Willick, is unclear whether that's a true statement or an untrue statement, but it certainly can be demonstrated. And this issue, like the other issues that I've talked about, either the defendant provides the proof to verify what he's indicating in his affidavit, or Mr. Willick will obtain it, and I will award attorney's fees to Mr. Willick for every dime that he has to spend to obtain the information that could have easily been provided by the defendant. We're not playing games anymore. We're trying to resolve and allow you people to move on separately with your lives rather than move it together. As far as the SVP is concerned, Judge Duckworth dealt with this back in December 2015. I understand that that he may or may not have understood the law at that point in time, but nobody appealed that decision, and that's still an order of the court. So in order to try and stay true to what Judge Duckworth wanted to do, here's how we're going to resolve that issue. I'm going to give the defendant the option, because I think that he should have an option at this point in time. He's either going to cooperate to allow a life insurance policy to be obtained in order to secure that benefit, and if he does not cooperate, then the order of this court is going to be that the plaintiff will obtain that SVP benefit on his retirement. I prefer to stay consistent with Judge Duckworth's order, and that's why I'm given the option of the cooperation for that life insurance that plaintiff is responsible to obtain. But she can't obtain it without some cooperation. So if there's no cooperation, then I'm going to order that she gets that benefit prior to the retirement occurring. Hopefully that's clear enough to be able to establish at that point. Sorry, I'm looking at my list. I think that's everything that was pending, unless counsel's aware of something that the attorney's fees issue is still outstanding. I'm hoping that we get cooperation from the defendant in order to avoid additional attorney's fees, so I'm going to hold off with regard to attorney's fees until we get that cooperation that the court anticipates we'll receive at this stage. Other issues, counsel, that are pending that I haven't resolved?
I don't have a list of any other issues. One small clarification from the exhibits.
Yes, sir.
The court's comment about the insurance. If you take a look at Exhibit 10, Ms. Kaufman's attempts to get the insurance in place go back to 2016. That is the messages between the two parties where she repeatedly requests assistance and cooperation, and he repeatedly says, basically, no.
And you're talking about the $400,000 from?
No, sir. I'm talking about the life insurance in replacement to the SPP. She's been trying to do this for 4 years.
No, I understand. And I'm hoping that the motivation that the SPP will be placed in plaintiff's name rather than his current wife's name will be enough motivation to have the defendant cooperate. If not, then I'm going to order that she be placed as the SPP.
Very good. Your Honor, because of the time limits in question and the mechanics and logistics, can we say that that cooperation has to be completed within 30 days?
Sure. I think that's reasonable.
Thank you.
Mr. Gabato, anything you're aware that I've left out?
No, I just wanted to clarify as to the first issue, the main issue, the issue of the order being stale. So the order is that basically that it's not stale, that the quadro is being entered.
That's correct.
Is that what we're doing?
Yeah, and that's just so the findings are clear. A couple reasons of getting to that point, one of which is that Judge Duckworth tasked your client with taking steps to make that happen and continue to do it, and your client doesn't get to benefit from his failure to cooperate with the court and to make that happen. So the court also maintained jurisdiction, Judge Duckworth maintained jurisdiction over these issues, so I don't believe that statute of limitations apply in this case. It is a community asset that should have been divided, wasn't divided, and the court doesn't find a basis to step aside from that now.
Okay. And just to be clear on the SPP, so as long as he cooperates to get the life insurance, his current wife, maintains the SPP.
That is correct.
All right.
I presume you wish us. Oh, I'm sorry. I did not mean to interrupt you, Alex. Your Honor, may
no interrupt.
I presume we should prepare an order for Mr. Gabato to review?
Yes. Mr. Gabato, is there something else?
No.
All right. Thank you both. Appreciate your efforts. We'll close the case.
Thank you for the time, Your Honor.
Thanks.